An indictment is a formal accusation, based upon available evidence, that a person has committed a serious crime. It is typically issued by a grand jury, a group of citizens who review the evidence presented by the prosecution. The indictment outlines the specific charges against the accused and serves as the basis for initiating a criminal trial. If there's enough evidence to prove that a person committed a crime, then they're indicted. The most important thing to know about indictments is that they're not required for every single crime. On a federal level, they're only required for felonies that will be heard by federal courts. States aren't required to indict every person who they believe has violated the law. That said, many states have passed laws that require an indictment to charge someone with a felony crime. These states include Massachusetts, New York, Ohio, and Texas. The confusing part is that an indictment can come at very different parts of the trial process. Some jurisdictions pursue an indictment prior to placing someone under arrest, while others place someone under arrest, and then send the case out for indictment. Most of the time, a person will know that the police are interested in them for a crime. It's normally not something that takes someone by surprise. Once an indictment is issued, it initiates the formal legal process against the accused. The defendant is then notified of the charges and given the opportunity to respond, usually through a court arraignment. The case proceeds to trial, during which the prosecution presents its evidence to prove the defendant's guilt beyond a reasonable doubt. Next, when to use. 1. Felony. An offense, other than criminal contempt, must be prosecuted by an indictment if it is punishable. A. By death, or B. By imprisonment for more than 1 year. 2. Misdemeanor. An offense punishable by imprisonment for 1 year or less may be prosecuted in accordance with Rule 58(b)(1). Waiving indictment. If the defendant waives indictment in open court after being informed of the charges against them and their rights, a crime carrying a sentence of more than a year may be prosecuted by information. Indictment's nature and contents. 1. In general, an attorney for the government must sign the indictment or information, and it must be a clear, concise, and documented description of the crucial details forming the offense accused. An official introduction and conclusion are not required. An accusation made in one count may be referenced in another count. A count may claim that the defendant committed the offense by unspecified means or that the defendant did so using one or more specific methods. The official or customary citation of the statute, rule, regulation, or other piece of law that the defendant is alleged to have broken must be included for each count in the indictment or information. When a defendant's identity is unknown for the purposes of an indictment as defined in Section 3282 of Title 18 of the United States Code, it is sufficient for the indictment to identify the defendant as someone with a specific DNA profile, as that term is defined in Section 3282, even though the defendant's name is not known. A case number, on the other hand, is a unique identifier assigned to a specific legal case. It is used to track and reference the case throughout the judicial system. A case number is typically generated when a complaint or initial legal document is filed with a court. It helps court personnel, attorneys, and parties involved in the case to identify and locate the relevant documents and proceedings related to that particular case. In summary, an indictment is a formal accusation of a criminal offense issued by a grand jury, while a case number is a unique identifier assigned to a specific legal case. An indictment is used to bring serious criminal charges against an individual or entity and initiates the legal process leading to a trial. A case number is used for administrative purposes to track and reference the relevant documents and proceedings of a specific case.
28 U.S. Code Section 1345, United States as plaintiff. Except as otherwise provided by Act of Congress, the district courts shall have original jurisdiction of all civil actions, suits, or proceedings commenced by the United States or by any agency or officer thereof expressly authorized to sue by Act of Congress. Title 28 of the United States Code contains laws related to the judiciary and judicial procedure in the United States. Section 1345 of Title 28 is titled United States as Plaintiff and describes the circumstances in which the United States government can bring a civil action as a plaintiff in federal court. Section 1345 states that the United States may be a plaintiff in any civil action, suit, or proceeding in any federal district court. This means that the federal government has the authority to initiate legal proceedings in federal court as a plaintiff, seeking remedies or relief in a civil matter. The provision grants the United States government broad standing to sue in federal court. It is often invoked in cases involving various federal agencies, such as those related to government contracts, taxation, regulatory enforcement, civil rights violations, and other matters in which the federal government has a legal interest. If you have any further questions, write them in the comments box, and we'll provide more information. 28 U.S. Code Section 2672, Administrative Adjustment of Claims. The administrative procedure established in accordance with 28 U.S.C. 2672 is intended to be a quick and inexpensive forum for the resolution of tort claims. This advice is given to agencies in order to help them use this administrative procedure more effectively and to make the most of the gains made using quick, equitable, and effective methods that settle administrative tort claims informally without putting the claimants or the agency under undue financial or administrative burden. In no way does this section grant any claimant the right to enforce any provision of this part against the United States, its agencies, their officials, or any other person. It just serves as a guideline for the agencies. The use of any dispute resolution method or procedure is not mandated by this provision for any agency. Delegation of authority, in accordance with and subject to the restrictions imposed by 28 U.S.C. 2672, the head of an agency or his or her designee may ask for delegations of authority to make any award, compromise, or settlement without first receiving the written consent of the Attorney General or the designee of the Attorney General. The following factors must be considered when deciding whether to grant the agency additional authority under 28 U.S.C. 2672. I. The extent to which the agency has established an office whose duties expressly include the administrative resolution of claims brought under the Federal Tort Claims Act. 2. The agency's experience with the resolution of administrative claims presented pursuant to 28 U.S.C. 2672. 3. The Department of Justice's experiences regarding the administrative resolution of tort claims arising out of the agency's activities. Monetary power, any award, compromise, or settlement of a claim by an agency under 28 U.S.C. 2672 that exceeds $25,000 or the amount of authority granted to the agency by the Attorney General under 28 U.S.C. 2672, whichever is greater, may only be made with the prior written approval of the Attorney General or his or her designee. A principal claim and any derivative or subrogated claims are treated as one claim for the purposes of this clause. According to the laws in force in the country where the act or omission took place, the agency director or designee is responsible for reviewing the claim and determining whether the United States would be accountable if it were a private corporation. Before making an award, making a compromise, or reaching a settlement, the Attorney General or their designee must give their written consent for claims worth more than $25,000. Procedure: the federal agency must submit a written referral or request to the director at any time after presenting a claim to the federal agency. This referral or request must contain 1. A brief and succinct statement of the facts and of the reasons for the referral or request. 2. Copies of relevant portions of the claim, and 3. A copy of the Department of Justice's advice as required by this section. It is important to note that this section does not grant authority to agencies to arbitrate, compromise, or settle claims arising from the activities of the Tennessee Valley Authority. 28 U.S.C. Section 1367, Supplemental Jurisdiction. Supplemental jurisdiction, also sometimes known as ancillary jurisdiction or pendent jurisdiction, is the authority of United States federal courts to hear additional claims substantially related to the original claim even though the court would lack the subject matter jurisdiction to hear the additional claims independently. Any civil action of which the district courts have original jurisdiction, the district courts shall have supplemental jurisdiction over all other claims that are so related to claims in the action within such original jurisdiction that they form part of the same case or controversy. Such supplemental jurisdiction shall include claims that involve the joinder or intervention of additional parties. In any civil action of which the district courts have original jurisdiction founded solely, when exercising supplemental jurisdiction over such claims would be inconsistent with the jurisdictional requirements of Section 1332. Next, the district courts may decline to exercise supplemental jurisdiction over a claim if 1. The claim raises a novel or complex issue of state law. 2. The claim substantially predominates over the claim or claims over which the district court has original jurisdiction. 3. The district court has dismissed all claims over which it has original jurisdiction, or 4. In exceptional circumstances, there are other compelling reasons for declining jurisdiction. The period of limitations for any claim asserted for any other claim in the same action that is voluntarily dismissed at the same time as or after the dismissal of the claim shall be tolled while the claim is pending and for a period of 30 days after it is dismissed unless state law provides for a longer tolling period. However, Section 1367 also provides discretion to the federal court in deciding whether to exercise supplemental jurisdiction. The court may decline to exercise supplemental jurisdiction if it determines that the state law claims substantially outweigh the federal claims, if the federal claims have been dismissed, or if there are other exceptional circumstances that justify declining jurisdiction.
Section 1331 of Title 28 of the United States is a federal statute that provides the basis for federal question jurisdiction in the United States. It grants federal district courts original jurisdiction over civil cases that arise under federal law. Typically, in order to have federal question jurisdiction, the plaintiff's complaint must be a well-pleaded one. This means that the plaintiff's initial complaint must contain references to the federal question and the federal issue evoked. The United States Code's General Federal Question Jurisdictional Provision, Section 1331, gives federal district courts original subject matter jurisdiction over all civil actions arising under the Constitution, laws, or treaties of the United States. In federal court, most civil cases are governed by this act. It is shocking to realize that we don't have a clear understanding of what statutory federal question jurisdiction involves given the important doctrinal and practical repercussions that follow from assessing whether a claim is covered under 1331. When a plaintiff asserts a substantial claim founded directly upon federal law, Professor Mishkin famously advanced the traditional notion that 1331 jurisdiction exists. However, neither this approach nor any other has been able to convince the federal courts to develop a cohesive theory or practice of 1331. However, this does not imply that 1331 jurisdiction is always a mystery. Undoubtedly, a plaintiff's lawsuit bringing a federal claim will almost always fall under 1331, while a plaintiff's lawsuit bringing a claim based on state law won't. The presence of 1331 jurisdiction is still difficult to ascertain in a sizable number of cases, nevertheless. Federal courts have jurisdiction over civil cases involving federal questions under Section 1331. When a plaintiff's claim is founded on a cause of action that results from the United States Constitution, federal legislation, or international agreements, it becomes a federal question. The federal issue must be significant and really contested in the case. The federal question must be raised in the face of the plaintiff's well-pleaded complaint in order to establish federal question jurisdiction under Section 1331. This means that a federal question must be stated in the plaintiff's complaint as a core part of the claim rather than as a defense put up by the defendant. The federal question must be a significant component of the plaintiff's claim and be grounded in federal law. A federal statute, rule, clause of the Constitution, or treaty can be considered a federal law. If the federal issue constitutes a crucial component of the plaintiff's claim, The lawsuit does not have to entirely concern federal law. Federal question jurisdiction under Section 1331 complements the traditional jurisdiction of state courts. State courts have concurrent jurisdiction over cases that involve federal law, but plaintiffs may choose to bring their claims in federal court if they believe federal jurisdiction provides certain advantages or if there are federal law issues that need resolution. Additionally, the Supreme Court's appellate jurisdiction over matters involving federal issues is established by Section 1331. The Supreme Court has the power to examine and determine matters that lower federal courts or state courts have decided but that contain significant federal questions. If you have any further questions, write them in the comments box, and we'll provide more information. If you or anyone you know violates the law, contact the Department of Labor.
Rule 12(b) allows a party to assert certain defenses and objections by motion rather than in a responsive pleading. This rule provides a procedural mechanism for challenging the legal sufficiency of the opposing party's claim or pleading, allowing the court to dispose of the case or narrow the issues before trial. The various subsections of Rule 12(b) outline specific grounds on which a party can bring a motion to dismiss or request judgment on the pleadings. These grounds include lack of subject matter jurisdiction. 12(b)(1). This defense asserts that the court does not have the authority to hear the particular type of case or the specific claims made. Lack of personal jurisdiction. 12(b)(2). This defense challenges the court's power to exercise jurisdiction over the defendant based on the defendant's contacts or activities in the relevant jurisdiction. Improper venue. 12(b)(3). This defense contends that the lawsuit was filed in the wrong geographic location or jurisdiction. Insufficient process. 12(b)(4). This defense asserts that the summons or other initiating document was not properly served on the defendant. Insufficient service of process. 12(b)(5). This defense challenges the adequacy of the method or manner in which the summons or other documents were served on the defendant. Failure to state a claim upon which relief can be granted. 12(b)(6). This defense argues that, even if all the facts alleged in the complaint are true, the plaintiff has failed to assert a legally valid claim for which the court can grant relief. Failure to join a necessary party. 12(b)(7). This defense contends that the lawsuit cannot proceed without the presence of an essential party, and thus, the case should be dismissed. By filing a motion under Rule 12(b), a party requests the court to dismiss the case or a part of it based on one or more of these enumerated grounds. The court will review the motion and the opposing party's response before deciding. It's important to note that Rule 12(b) applies to federal courts in the United States and may have some variations or equivalents in different jurisdictions or legal systems. Rule 4 describes the conditions and steps for delivering summonses. Here are some key points covered in Rule 4. Content of the summons. The summons must include the name of the court, the names of the parties involved, the signature of the clerk, and the court seal, if applicable. It should also contain information about the time within which the defendant needs to respond to the complaint. Issuing the summons. The summons is typically issued by the clerk of the court upon the plaintiff's request. The clerk provides the plaintiff with multiple copies of the summons, and the plaintiff is responsible for serving it on the defendant. Service of the summons. The rule specifies various methods for serving the summons on the defendant, including personal service, leaving a copy at the defendant's dwelling or usual place of abode, or delivering a copy to an authorized agent. Service can also be made by mail or by other methods allowed by the court's local rules. Time for service. Generally, the summons must be served within 90 days from the date of filing the complaint. However, there are exceptions and extensions available under certain circumstances. It is significant to stress that any adjustments or modifications to Rule 4 would necessitate careful study, balancing the need for modernization and efficiency with protecting defendants' rights and ensuring proper notice in court proceedings. Before they could be adopted, Any proposed revisions would probably go through a rulemaking procedure that involved public discussion and review by the U.S. Judicial Conference.
According to the Fair Labor Standard Act 1938, a lawsuit shall be brought against employers under the FLSA Act. However, per requirements are set in order to enforce Section 29 U.S.C. 216b. The section provides a clear direction to the parties involved in the enforcement of 216b. Any employer who violates the provisions of Section 206 or Section 207 of this title shall be liable to the employee or employees affected in the amount of their unpaid minimum wages or their unpaid overtime compensation, as the case may be, and in an additional equal amount as liquidated damages. The condition pursues to find the violation prior to the enforcement, and finding violation must be identified by the Department of Labor, who is responsible to conduct the audits in order to find violations of Section 29 U.S.C. 206, 207, and 255. If the Department of Labor finds violations against any employers, the DOL can move to enforce 29 U.S.C. 216b to the Department of Justice. After finding the violation against an employer by the Department of Labor shall send memos to each worker involved in order to inform them about the violation and the opportunity to enforce the said violation against the employer. The letter shall instruct the workers to sign the consent and take an oath that shall be authorized by the court to enforce Section 18 U.S.C. Section 401 or 29 U.S.C. Section 216. The Department of Labor has to coordinate to comply with the summons and complaints and cover sheet, JS-44, to file it to the federal court under Section 18 U.S.C. Section 401 or 29 U.S.C. Section 216 to enforce the Social Security benefit under the federal law called FICA. Under the Section 29 U.S.C. 216a, any person who willfully violates any of the provisions of Section 215 of this title shall, upon conviction thereof, be subject to a fine of not more than $10,000, or to the imprisonment for not more than 6 months, or both. No person shall be imprisoned under this subsection except for an offense committed after the conviction of such person for a prior offense under this subsection. Employers who improperly classified nurses as independent contractors, and as a result, employers failed and refused to pay their employer's share of the Federal Insurance Contribution Act, FICA, taxes on each nurse's gross wages, and accordingly plaintiffs were required to pay the same. By employers' failure and refusal to pay their employer's share of FICA on behalf of nurses, employers were unjustly enriched. By employers' failure and refusal to pay their employer's share of FICA on behalf of nurses and failure and refusal to pay nurses for travel time between consecutive assignments, they exercised dominion over and appropriated such funds for their own use and benefit, thereby depriving nurses of the rights and benefits thereto. Accordingly, employers are guilty of conversion. As a proximate result of employers' conduct, as alleged herein, nurses suffer damages and are entitled to an award of compensatory and consequential damages. All other similarly situated employees are also entitled to damages in the form of uncompensated overtime wages, liquidated damages, attorney's fees, and other damages so as to preclude employers' unjust enrichment. Pursuant to Section 216b, attached hereto and filed with this complaint as exhibits A through late, the consent to become party nurses executed by each nurse.
State civil rights in the United States. State civil rights in the United States refer to the rights and liberties guaranteed to all individuals by the U.S. Constitution and various federal and state laws. These rights protect individuals from discrimination and ensure equal treatment under the law. While the federal government sets certain standards and protections, individual states also have their own civil rights laws that may provide additional protections or remedies for their residents. Here are some key aspects of civil rights in the United States. Equal protection under the law. The 14th Amendment to the U.S. Constitution guarantees equal protection of the laws to all citizens. This amendment has been the basis for many civil rights advancements and court decisions. Voting rights. Various federal laws, such as the Voting Rights Act of 1965, protect the right to vote and prohibit racial discrimination in voting practices. States also have their own voting rights laws. Anti-discrimination laws. Federal laws, such as the Civil Rights Act of 1964 and the Fair Housing Act, prohibit discrimination on the basis of race, color, religion, sex, national origin, disability, or familial status. Many states have their own anti-discrimination laws that may expand on these federal protections to cover additional characteristics, such as sexual orientation and gender identity. Education. The Supreme Court case Brown v. Board of Education, 1954, declared racial segregation in public schools unconstitutional. Education is a fundamental civil right, and states have a duty to provide equal educational opportunities to all students. Employment rights. Laws like Title VII of the Civil Rights Act protect employees from workplace discrimination on the basis of race, color, religion, sex, and national origin. States may have their own employment discrimination laws. Housing rights. Fair housing laws at the federal and state levels aim to prevent discrimination in housing and ensure equal access to housing opportunities. Criminal justice and due process. The right to a fair trial, legal representation, and protection from cruel and unusual punishment are fundamental civil rights. Issues related to policing, bail, sentencing, and prison conditions also fall under civil rights concerns. Freedom of speech and expression. The First Amendment of the U.S. Constitution protects the right to free speech, religion, and assembly. These rights are essential components of civil liberties. Privacy rights. While not explicitly mentioned in the Constitution, the Supreme Court has recognized a right to privacy in various contexts, including reproductive rights and personal information. Disability rights. The Americans with Disabilities Act, ADA, prohibits discrimination against individuals with disabilities in various areas, including employment, public accommodations, and transportation. Many states have similar laws. Personal jurisdiction. Personal jurisdiction refers to the power that a court has to make a decision regarding the party being sued in a case. Before a court can exercise power over a party, the U.S. Constitution requires that the party has certain minimum contacts with the forum in which the court sits. It is a fundamental concept in the legal system that ensures fairness and due process in legal proceedings. Personal jurisdiction determines whether a court has the right to hear a case and render a binding judgment against a defendant. Waiving personal jurisdiction. Personal jurisdiction can generally be waived. Contrast this with subject matter jurisdiction, which cannot be waived, so if the party being sued appears in a court without objecting to the court's lack of personal jurisdiction over it, then the court will assume that the defendant is waiving any challenge to personal jurisdiction. In order for a court to exercise personal jurisdiction over a defendant, certain requirements must be met. These requirements vary depending on the jurisdiction and the type of case involved, but generally, there are two main types of personal jurisdiction. General jurisdiction. A court has general jurisdiction over a defendant if the defendant has such extensive contacts with the jurisdiction that it is considered to be at home there. Typically, this means that the defendant is a resident of the jurisdiction or has a principal place of business there. Under general jurisdiction, a court can hear any type of claim against the defendant, even if the claim is unrelated to the defendant's contacts with the jurisdiction. Specific jurisdiction. A court has specific jurisdiction over a defendant if the defendant's contacts with the jurisdiction are directly related to the claim being brought against them. The court's power is limited to the specific issue or transaction that gave rise to the claim. In order for a court to exercise specific jurisdiction, the defendant must have sufficient minimum contacts with the jurisdiction, and the exercise of jurisdiction must be fair and reasonable. Determining whether a court has personal jurisdiction over a defendant can be a complex legal analysis that involves considering factors such as the defendant's physical presence or business activities within the jurisdiction, the nature of the claim, and any applicable state or federal laws. Typically, for a court to have personal jurisdiction over a defendant, the plaintiff needs to serve the defendant in the state in which the court sits, and the defendant needs to voluntarily appear in court. Federal Rules of Civil Procedure Rule 4(k) describes whether a state's courts would have the authority to adjudicate a claim as it relates to personal jurisdiction. The rules and standards for establishing personal jurisdiction can vary between countries and even within different regions or states within a country.